by Emma Amaize, Regional Editor, South-South. The Economic and Financial Crimes Commission, EFCC, and the senator representing Delta North Senatorial District, Chief Peter Nwaoboshi, have been at daggers drawn for about 2 years, but the brawl took another dimension, April 23, when snooping operatives of the anti-graft agency took into custody the former chairman of People's Democratic Party, PDP, in Delta State, over alleged sleazy deals. EFCC, which had temporarily seized a 12-story building, popularly known as Gunny House, bought by the lawyer-politician from the Delta state government, some years back, after obtaining a court order to the effect, claimed that the politician was evading summons. A federal high court judge, Justice Abdulaziz Anza, following an application by EFCC, April last year, ordered a temporal forfeiture of a 12-story building at 27 Marine Road, Apapa, Lagos, popularly known as Gunny House, Golden Touch Construction Project Limited, but later sold Swimming Electricals Limited from the Delta state government. The anti-graft agency traced both companies to Nwaoboshi, and both sides have evolved several tricks to ambush and outmaneuver each other for over a year on the matter. Golden Touch and Swimming Electrical became the first to drag EFCC to the Federal High Court, Asaba, in March 2017, seeking an order to restrain it from interfering with their ownership of the Gunny House, among other reliefs, following a siege on the property by the Commission, earlier that month. Justice Oyabang presided over the matter, but before he delivered judgment December 14, 2017, roughly 8 months later, EFCC took the matter to another federal high court in Lagos, almost resulting in a judicial fiasco. The EFCC case against Nwaoboshi and Asaba. Justice Oyabang captured the EFCC case before his court. Thus, on the 3rd of October 2017, the first defendant, EFCC, called its witness. He is Ani Davis Stanley, a staff of EFCC. The witness statement on oath dated 19 June 2017 was admitted in evidence and marked Exhibit D1. The witness stated that a case of fraud and abuse of office was reported to the office of the executive chairman of EFCC via written petition dated the 22nd of February 2016 by Comrade Prince Kapokri, the chairman of the Anti-Corruption and Integrity Forum, against Senator Peter Nwaoboshi, who is currently representing Delta North Senatorial Zone, Delta State, and Chairman, Senate Committee on Niger Delta Development Commission, NDDC. He further stated as follows, that the complainant in his petition alleged that Senator Nwaoboshi's company, Bilderberg Enterprises Limited, was awarded a contract by the Direct Labor Agency, Delta State, to supply construction equipment in the sum of N$1.580 billion. Instead of supplying according to specification, the suspect supplied used equipment contrary to the bill of quantities, which specified new ones. The petitioner also alleged that same company was awarded another contract to supply machines like bulldozers, tail loaders, tippers and lorries at a staggering sum of N$494.936 million by the Delta State Waste Management Board under the auspices of Delta State Ministry of Environment, which the company equally supplied used ones. The witness then stated that the petitioner alleged that suspect laundered the proceeds of his corrupt practices through purchasing an expensive landed property in Delta State and Lagos State. That one of them is a 12-story building known as Gunny House, property of Delta State government in Apapa, worth N$4.5 billion. The witness further stated that upon receipt of the petition, the complainant and several witnesses were invited and their statement taken voluntarily. That several letters of investigation activities were sent to various agencies of Delta State government and agencies of the federal government and various banks where suspect maintains about 26 accounts requesting for necessary information, the court said. According to the judgment, the EFCC witness told the court that its investigations showed that Senator Nwaoboshi used the name of Golden Touch Construction Project Limited to purchase Gunny House, did not declare all the companies and the bank accounts he has interest in before the Code of Conduct Bureau, and stated in his Code of Conduct Bureau Assets Declaration form that he is a director in Golden Touch Construction Project Limited, contrary to the details obtained from the Corporate Affairs Commission that Mr. Nwaoboshi and Emma Amaize are directors of the company. The two-count charge in Lagos. After his arrest on April 23, Nwaoboshi and his supposed two firms were arraigned the next day, April 24, before a federal high court, Lagos, on a two-count charge of money laundering and fraud of $805 million slammed on them by the Economic and Financial Crimes Commission, EFCC. He pleaded not guilty to the charges. The senator was alleged to have acquired Guinea House for the sum of $805 million when he reasonably ought to have known that $322 million out of the purchase sum formed part of proceeds of an unlawful act. The sum was said to have been transferred to the vendors by order of Snooping Electrical Limited. Snooping Electrical was said to have on May 14, 2014, aided Nwaoboshi on Golden Touch to commit money laundering. The offenses contravened the provisions of Sections 15(2)(d), 15(3), and 18(a) of the Money Laundering Prohibition Act 2011 and are liable to punishment under Section 15(3) of the same act. He pleaded not guilty to both charges and was granted bail 4 days after, April 27, by the trial judge, Justice Muhammad Idris. Position of Delta Govt recording a testimony before the Federal High Court, Asaba, Justice Abang noted, witness to Delta State Government, Ministry of Housing and Attorney General, who are the second to fourth defendants, a Director of Public Building Department, Ministry of Housing, Asaba, Architect Edward Emma Amaize, told the court. Learned counsel to the first defendant in his written address only addressed the issue as regard the fact that EFCC is a statutory body created by law to investigate financial and economic crimes and that the court cannot restrain it from performing its statutory duties. There is no dispute as regard the above. But the issue is whether or not EFCC is a statutory body created to investigate financial and economic crimes is entirely, in my view, different from the issue whether there was indeed a valid sale of the property to the first plaintiff by the second and 3rd defendants. Learned counsel for the first defendant's written address was not in any way helpful to the court in this regard. The defense of the first defendant in this matter is that its investigations revealed that Senator Peter Nwaoboshi used his company, Golden Touch Construction Project Limited, to purchase a 12-story building in Apapa, Lagos, property of Delta State Government at the cost of $805 million, which part of the money came from Snooping Electrical Limited's account with Zenith Bank, a company he used in collecting loan from Nexim Bank. Money laundering purely in the sphere of accusation on the money laundering charge, the judge said. The contention of EFCC that the first plaintiff laundered money being the proceeds of contract awarded to it that was used to purchase Guinea House is a criminal allegation made in a civil proceeding. On this, I agree entirely with the learned counsel to the plaintiffs, Onyeka Ehiwagwu, that the first defendant must prove beyond reasonable doubts that the plaintiffs purchased the property with money obtained from proceeds of money laundering, thereby acquiring the property by fraudulent conversion and corrupt practices. With the facts placed before me in this matter, the issue of money laundering on the part of the plaintiffs is merely in the realm of allegation. No established fact has been led in evidence indicating that the sum of $805 million paid by the first plaintiff to second and 3rd defendants is a product of fraudulent conversion and corrupt practices. There is no evidence before the court, not to talk of one being conclusive to the effect that the sum of $805 million used to purchase Guinea House was money laundered from the proceeds of crime. See Sharomo vs. State 2010, 19 NWLR, pt. 1226, page 73. I also agree with learned counsel for the plaintiffs that the first defendant did not adduce evidence of how the plaintiffs acquired the said sum. Contrary to the submissions of the first defendant's counsel, Sir Steve Odies in paragraph 2.10 of his written address, it is not the duty of the plaintiffs to lead evidence as regard the sources of the money used to purchase the said building or that the money used for the purchase of the property was not a preceded crime. He who asserts must prove. The burden is on the first defendant to prove that the money used to purchase the property was preceded crime. Court can't act on allegation, this cannot be inferred. What is before me is just in the realm of allegation. This is not a sentimental issue. A court of law acts on facts. A court of law cannot act on allegation or speculation. If indeed it is true that the equipment supplied to Delta state government by the first plaintiff or by the distinguished senator were used equipment or substandard, yet the first plaintiff was paid for the contract awarded in 2010 and it used the money to buy property in 2015, a period of 5 years, EFCC must first of all prove that the contract was poorly executed or not properly executed at all, yet the first plaintiff was paid. In this regard, EFCC must also prove how the money was paid to the first plaintiff, whether by cash or by check. The bank that the money was deposited in, that it was the proceeds of the contract poorly executed that was used to purchase the property. The bank the money was deposited must be mentioned in evidence. EFCC operatives, EFCC must prove that, in that account, no other funds was deposited by the first plaintiff and it is from that particular account, that checks for the $805 million was drawn. It is not sufficient in my view that heavy weather as regard the allegation was made that it was preceded crime that was used to purchase property. No proof to connect plaintiffs to money laundering. Justice Bank stated, "It is my humble but firm view that since there is no evidence provided by the first defendant linking the purchase price of the property with money allegedly laundered by the plaintiffs from proceeds of contracts issued by Delta state government that the one state defendant claimed. There, I endorse that the writ of summons deserves to succeed and it is accordingly granted as prayed. I so hold," the judge added. Forestalling judicial anarchy based on its findings that the transaction leading to the sale of Guinea House between the plaintiffs and defendants were genuine, the court said it would have made an order concerning the EFCC intrusion. Justice Abang said the court was disarmed by a forfeiture order of the said Guinea House already made by the Lagos Division of the Federal High Court on April 21, 2017. His words, though the detour by EFCC to another division of the court where it obtained the order was brought to the knowledge of the court and the evidence of first defendant's witness under cross-examination and the enrolled order not placed before the court, Justice Abang stated, this piece of evidence was not challenged by the plaintiffs. Now the question is Lagos Division of this court having made an interim order forfeiting the property to federal government, this court is presently constituted having had knowledge that such order has been made by the Lagos Division of this court. Can this court, being a court of coordinate jurisdiction with Lagos Division of this court, make an order directing that the plaintiffs be allowed access to the premises to effect repairs? My lords, I think not. I so hold. Finding a way around, he said, the plaintiff's counsel submitted, and rightly so, that the instant suit was filed before the first defendant filed suit no FHC, LCS, 584-2017 at the Lagos Division of this court on the same subject matter. He submitted that the suit filed by the first defendant on the same subject matter is an abuse of court-'s process and relied on the case of Suraki vs. Kadoy, 1992, and WLR, PT. 264, at p. 156. I have already held in this judgment that having regard to finding made in Relief 1, that it is deserving to make an order granting access to plaintiffs to enter the premises to continue with the repair work pending when EFCC concludes its investigation. However, granting such order in this matter will be in direct conflict with the order of interim forfeiture of the property made Lagos Division of this court. It is settled law that I have no jurisdiction to make an order that will be in conflict with the order made by a judge of coordinate jurisdiction. Supreme Court in the case of Union Bank Limited versus IMB Supra held that a judge of coordinate jurisdiction cannot make an order that will neutralize the effectiveness or the potency of an order made by a judge of coordinate jurisdiction. Though it is deserving that I make such an order, but I cannot take such risk in making an order that will violently be in conflict with the order of interim attachment made by the Lagos Division of the Court. There is an order of interim forfeiture of the property still subsisting. If I now make an order directing the plaintiffs to enter the premises for repair works, though deserving for such order to be made in the circumstances of this case, the order, if made, will definitely neutralize the effectiveness of the order of interim forfeiture made by Lagos Division of this court, and the legal combatants, that is the parties, will be confused as regard which of the two orders is to be obeyed. Abuse of court process. No jurisdiction to make findings on the order of interim forfeiture made by a court of concurrent jurisdiction, he said. This can lead to anarchy and confusion. More so, this court cannot sit on appeal over a decision of brother judge. If I make an order granting access to the premises, it would seem that I have sat on appeal and reviewed a decision of brother judge. I have no jurisdiction to do so. I cannot in this proceeding say that the suit filed in Lagos Division is an abuse of court's process because I have no jurisdiction to make such findings. Though the fact that if an order made by a trial court is a nullity, a judge of coordinate jurisdiction can set same aside. However, the issue is regard whether the order EFCC may have a joker. Justice Abang's judgment was clearly based on the evidence given by EFCC as at the close of evidence on October 4, 2017 in his court, but it appears with fresh arraignment of Nwaoboshi and the two companies that it could have stumbled on new facts. If so, the new judge handling the matter will make his pronouncement at the end of legal fireworks by both sides.